The Mountain West submits counterclaims against the PAC-12.
Conference realignment and lawsuits are always in the news, so we're back on the Big Mountain to keep you updated.
Hey, welcome back to the Big Mountain. I am JY. This is my good friend Steve. Steve, another lawsuit update that we have. It's been a little bit, but back on October 23rd, so about a week and a half ago, the Mountain West issued a response to the PAC lawsuit in the federal court in Northern California, and also issued some counterclaims. We're going to go through this whole thing. Several kind of chunks that I want to make sure we hit on. The counterclaims are going to be at the end, and these are actually claims that the Mountain West is submitting, almost like a separate lawsuit,
Right.
if you will, against the PAC and things that they have done. For those that have followed us, Steve, for a little while, I have said I've been waiting for the Mountain West to bring forth some claims. And of course, they did it just kind of as part of this PAC lawsuit, not a separate lawsuit. So that clearly makes sense. And just as a reminder, this lawsuit is about the scheduling agreement with the PAC. This has nothing to do with the exit fees for the departing members. You know, there's 3 members. That's a separate court in the state of Colorado, and that's not what we're talking about here. This is purely the termination fees within the scheduling agreement. So just want to make sure we're clear on that. This was an 86-page filing, and really the first half of this, about 43 pages, just goes over paragraph by paragraph the PAC lawsuit, and the Mountain West says whether or not they agree or deny the allegations within the lawsuit. I'm going to not talk about that at all.
Right.
We've already gone over these lawsuits. If you're interested in hearing the details about this, just check out our channel. Not going to waste time, just reiterating things and re-saying things we've already kind of talked about. So what we're going to get into focus here are the defenses the Mountain West has put forth. We've talked about some of that before, but I want to make sure we hit on that again. And like I said, at the end, we'll get into the counterclaims, claims that the Mountain West has now that they have submitted against the PAC. And I have to say up front, there's a few things here that the Mountain West has put in this filing and in their counterclaims that I've kind of been waiting to come up in court. And we're going to get a glimpse of some of these items now. And I'll put a couple things up on the screen for you. So first, let's just quickly break down the defenses. The Mountain West here lists 11 defenses and adds substance to each of these. I'm going to highlight these fairly quickly because I really want to focus mostly probably on the counterclaims. That's kind of the new stuff for the most part. So here we go. I'll go through these 11 pretty high level. Number 1, lack of antitrust standing. Of course, we've talked about this before. They already talked about this with their motion to dismiss, that there is no antitrust standing and that the PAC cannot bring these claims against the Mountain West. Number 2, a commerce clause. This has to do with the 3 different claims. The third claim here from the PAC about the California Cartwright Act. And the Mountain West is stating here that this should be barred because the case is dealing with interstate commerce, and this, California Act unduly restricts interstate sports leagues and things like that. So they're saying because this is interstate, you can't hold one state's Cartwright Act or whatever it may be to this type of an agreement. Number 3 is complete involvement. This defense is for both the Sherman Act and the Cartwright Act. So really they're 3 of the 4 claims that the PAC brought forward here. Basically saying all parties were represented by legal experts. They all had counsel when they were going through this agreement. Part of that was drafting and approving the scheduling agreement. So everybody was involved in this. This wasn't a one-sided type of deal is what they're getting at here. Number 4, unclean hands. We've talked about unclean hands before in some of our lawsuit episodes. This has to do with the PAC acting, or in this case, not acting equitably and in good faith. Number 5, equitable estoppel. The Mountain West says they were harmed by the PAC's conduct, actions, omissions, and communications. Thus, the PAC is estopped from asserting claims on the conduct, commitments, and assurances within this agreement and its negotiations. Number 6, ancillary restraint to a pro-competitive agreement. Here the Mountain West states that the anti-trade counts are barred because the portions in question here are a part of a full pro-competitive agreement. Also, the PAC cannot substantiate any anti-competitive effects that outweigh the pro-competitive agreement that fall under the rule of reason. There's a lot of terminology in here that's much more deep legal mumbo jumbo than I'm going to get into right now. But basically they're saying that this agreement is more pro-competitive, and they get into the rule of reason, which gets into some of this anti-trade types of items that outweighs any sort of anti-competitive type of effect this agreement may have. Lack of causation. The Mountain West states that the alleged damages here was not caused by the Mountain West, but from the choice that the PAC made as part of the known and agreed to scheduling agreement. The PAC cannot establish causation between the alleged harm and the Mountain West alleged conduct. Again, the scheduling agreement was made by both parties with lawyers fully involved on both sides. Number 8, lack of cognizable injury. Damages and injury are purely speculative here in this case, and the PAC cannot establish injury. Number 9, enforceable contract provisions. The challenged provisions provide an alternate method of performance. At the time of the agreement, the parties and their counsel agreed that the termination fees were a, quote, fair, reasonable, and appropriate approximation of the Mountain West potential loss. So you're going to hear this a lot. We've talked about this a lot. We talked about it in several of the other cases. This is an alternate method of performance outside of liquidated damages. But even if it is liquidated damages, the Mountain West is going to tell you it's still fair, reasonable, and appropriate because we have agreed to this being the actual potential loss. And that's very important. That's something people have talked about before. This number's out there. It doesn't mean anything. Now, they don't give us the detail on that. That'll happen in discovery and as part of the court case and all of that. But the Mountain West is saying it was fair, reasonable, and appropriate as determined by both counsels and parties. Number 10, non-duplicative fees discusses the difference between the termination fees in this agreement and the exit fees in the bylaws, which would be the other lawsuit. Not talking about that. But here they're talking about the difference between these two types of fees, and that the termination fees were for unique and specific harm that the PAC inflicted on the Mountain West. They go into a little more detail there, but again, it's just talking about the difference of the termination fees and the exit fees. And then lastly here, number 11, failure to join the parties. This states that both Washington State and Oregon State should be joined parties in this lawsuit. Basically saying, the plaintiffs here bringing the lawsuit should be the PAC plus Washington State plus Oregon State. This is something I believe that can be done via an amendment. I think, they're bringing this saying they're not asking for an amendment, but I think that can happen. I believe that happened 2 years ago with the original PAC case when they were talking about who the parties were. Maybe we never got there, but I know that was something that was talked about. So I'm going to stop there, Steve, for the time being, give you an opportunity to just give some thoughts.
Well, I think you can kind of start to see what their overall strategy is. When we talked about the original filing, we talked about the antitrust issues, Sherman Act and all that, and we said that was basically the PACs. They were going for the silver bullet. Like, if you can knock this down as an antitrust case right away, it just blows everything up.
Yes.
Well, you can see that the Mountain West, their counters here are really, they're trying to stamp down the antitrust issues.
Right.
But then also, and which I think is their smartest and possibly easiest argument, is the whole Cartwright thing. I mean, this is the Commerce Clause is a long established. People use it all the time. It's very powerful. It's long. There's a lot of case law that's been determined on that. And if they can get the Cartwright Act issues in California knocked down, that's huge for them. And I think it's just one of the most doable things because this is obviously interstate commerce.
Right.
I mean.
Right.
Now, if this wasn't the Mountain West against the PAC, if this was just like two schools in California arguing that against one of the conferences, then you could keep that. But this is obviously interstate conference or interstate commerce. So that's the two things. They're trying to kind of just stamp down the antitrust allegations just as a whole, which I think is very smart because that's the danger to their case.
Yeah.
And then also getting the Cartwright Act part taken off because it's obviously interstate commerce. Those are my main thoughts. A lot of the other stuff, like you said, we saw this in the original PAC case. We saw this in some of the FSU, ACC stuff. I think they're just, the whole arguing about cognizable injury and all of that stuff, that it's not a duplicated penalty. I think those are kind of normal things that they'll go for. I'll be interested to see what their what case they make if this goes on.
Sure.
But I think it's very clear the PAC silver bullet is antitrust. And the Mountain West is trying to knock all that down because that's probably the key, most important part of the case. Because if the judge finds there is antitrust violations, it doesn't matter what any of the penalties, this and that, it's just gone. So I think there are a lot of really smart things in here and a lot of them that are just the routine that you got to do.
Agree. Well, let's get into kind of the next section here. It goes over just the background. It lays the landscape for the court, who the parties are, all that kind of jazz, what led up to this. Not going to bore everybody with that. For the most part, everybody knows. There are two sections in this that I do want to talk about before we get into the counterclaims here.
Can I say one last?
Absolutely, yeah.
I really think it's smart of them to drag OSU and Washington State in here as parties because now we've talked about this before. When what makes people settle? When they think they're in danger. And so if you can do that and bring them into it, they can't just hide behind the PAC and the resources of the PAC. They are brought into this and they have some jeopardy to them. I think that's it's a big point and I think it's very important.
I agree, right? Because right now it's just really the PAC resources and assets and potentially...
Which are limited.
Especially, right, with the counterclaims, which are limited. If we can bring these other parties in, these public institutions, that brings a little more, potentially, more stressor on this case. So, and that leads me right into the first part I want to talk about, and it is the negotiations around the termination fees, right? This is what we're all here for. This is why we're talking about these cases. And it states here that the Mountain West states here that 4 parties, exactly to your point, the PAC, Oregon State, Washington State, and the Mountain West, all 4 of those parties were involved and each expressly acknowledged the harms posed by selectively recruiting a conference's teams. The 4 parties, again, including Oregon State and Washington State, to get to your point and what they put in there, the 4 parties negotiated the agreement to avoid those harms. They agreed to possibly discuss a 14-team conference while giving the PAC-12 and the 2 schools at the time flexibility to choose alternative paths. And we talked about that over and over again, especially early on. They just want to keep as many plates spinning as they possibly can. If they can get an invite to a P4, if they can do this, you could see that. It's completely trying to keep, we covered that in depth when that was going on. OSU's president and their AD stated that the agreement left open every possible option. We talked about that many times. Also, the PAC secured a concession from the Mountain West known as the withdrawal fees. Now, I've been calling them termination, withdrawal. I think they maybe use those words interchangeably here. But the withdrawal fees, that would be payments made as the sole and exclusive remedy for the PAC if they cherry-picked Mountain West members. And yes, cherry-picked was put into this by the Mountain West several times in this section.
Which just means selectively picking and not inviting all of them.
Yeah, exactly, right. And they go on to say this was an arm's length risk allocation, not duress. So I wanted to make sure we highlighted that because you hear this duress claim a lot. The Mountain West is saying this is an arm's length risk allocation, or again, kind of spreading out your risk, keeping your options open, maybe this, maybe that. It wasn't duress. That's for a judge. I'm not judging that and saying that's right or wrong. I have an opinion on that, but that's what the Mountain West is saying. The next section that I thought was pretty interesting, and they called it here, the PAC-12's covert interference is exposed. And I'm not going to go through everything that was in this. I'm going to hit a couple items. Some items I kind of figured were going to come back in lawsuits, and they have, but I'm not going to go over everything. If you're interested in this, I'd say read it. It's maybe 4-ish pages. It is very interesting to kind of read all of this. Here, the Mountain West points to several public statements and one photo that I always found to be very interesting. First, they point to Utah State's AD at the time, Sabo's comments that, and I think she was speaking to boosters or something. I heard the video. I was a little surprised when I heard it. But anyway, her comments were that she knew that 4 schools were going to depart for the PAC and would do so a month before the announcement. She knew this a month before the announcement. And that obviously suggests that she had been in contact with the PAC-12 or its agents well before the public timeline. Further remarks that she made was about her presenting 18 presentations to demonstrate that the PAC's, and this demonstrated the PAC's discussion and strategy was in motion long before any sort of public disclosure or the breakdown of the extension to the scheduling agreement. This raises the specter, according to the Mountain West, that the departing schools were intentionally trying to sow division between the Mountain West and the PAC-12 to destabilize the conference. Going on here, this is from the Mountain West. On information and belief, the PAC and its constituents decided early on to dismantle the Mountain West, take 4 to 6 members, bleed the Mountain West dry, and then force a vote to dissolve. On September 17th, 2024, Utah State President Cantwell, again at the time, she's now actually at Washington State, interesting. But anyway, President Cantwell attended a special Mountain West meeting regarding the future of the Mountain West. This was right after the 4 announced they were leaving. And they were talking about the future, inviting new members, and she never disclosed that Utah State was in a conflict of interest because they have had ongoing conversations per AD Sabo's discussions, kind of public discussions, and clearly knew where the PAC stood, and the PAC could potentially have insider information from Utah State. That's what the Mountain West is saying here.
The call is coming from inside the house.
There you go. Certainly looks like that. Again, people can, believe what they want, but I think the connecting the dots here really isn't that difficult. Utah State then announced its departure from the Mountain West only 6 days after that meeting where President Cantwell was kind of at the table figuring out what the future of the Mountain West would look like. The Mountain West goes on to state several instances of the departing members' conflict of interest. Again, I'm not going to go through all of these, but they show several conflicts of interest, including a picture that was taken and posted on X. I retweeted it. I've retweeted it since. It was taken by then President Schultz that showed the departing members sitting at a table with Washington State, Oregon State, and the PAC, specifically Commissioner Gould. And this was, I don't remember the exact date. I'll throw it up on the screen so you all can see it. I found it very interesting that they took this picture and made it public when the departing members were still members within the Mountain West. We're going to get into some of that timeline here in a little bit. Lastly, they cite a statement by San Diego State Athletic Director Wicker. If you remember, he just couldn't keep his mouth shut for quite a while. Yes. He seems like he has now recently. But he confirmed that the PAC never negotiated a definitive transaction in good faith. And they cite him saying that. So I'm going to open it to you again, Steve, and then we'll get into the kind of the claims of relief that the Mountain West is bringing forward.
So I don't know that I have any comments on particular parts that they're citing off evidence that they can tie a whole picture together, which,
right.
Connect the dots, like you said.
Yeah.
So I don't necessarily have any comments because I think they're doing what they have to do. They're making smart kind of counter allegations and streaming along together, kind of in order. This proves that, this supports that, and all that. Just that's what they have to do, and I think they're doing a good job of that. My bigger overall picture thought, and I was going to save this for the end, but It's so laid out here in this part of it. Not necessarily just the people that they're citing in this case, where we have public universities, we have athletic directors and presidents who are making these massive decisions. And when they look inept in certain ways.
I'm glad you said that,
Yeah,
because
and
I think so.
Right, and they're moving around. By the time the court cases come, they're moving around to different schools, different conferences. You have one right now that's, like you said, now at Washington State.
Right.
So what I'll say is, in the bigger picture of college football, and this is something you and I have talked about basically since the original PAC lawsuit.
Yeah.
And we talked about with the Florida State case and all that. And now we see LSU, what's happened just with LSU, where the governor basically had to step in and said, we're not doing this crap anymore. These stupid contracts, agreements, and whatever. I think the biggest fallout of this, and I don't know which way it's going to go, probably some kind of a settlement where neither side is happy. That's usually what happens. But I have no idea where this case is going to go, but I think this is going to have a big influence. We saw the Florida State issue. We see LSU now. In this environment of realignment, the money is bigger for all of these schools. Everything for hiring coaches, joining, making agreements, leaving conferences, all that. The money is getting bigger and bigger. And for these public universities, I think we're going to see more and more of the politicians getting involved, the governors, the attorney generals, the state boards, or whatever, because you see these ridiculous actions of ADs, presidents, and all this. These agreements, I wouldn't be surprised if some states start to basically force their public universities to have any contracts agreements, whether it's between schools, conferences, whatever, or with a coach. Have them get these vetted by like the state attorney general or something, because we're talking millions, tens of millions, hundreds of millions of dollars, and you think, what the heck were these people doing? Like, and again, I don't want to take sides between Mountain West and PAC. I don't have a horse in that race, but. Sure. If you're doing something that's potentially breaking a contract, why the heck would you go and have a picture taken and let it get released in some way? That's like if you're you're not supposed to drink alcohol because of a judge said you couldn't, and then you post a picture of you and all your buddies drinking beer. Like, what are you thinking? So that's my thoughts.
Well, let's get to the claims of relief. So again, these are claims that the Mountain West is bringing. Both in this case, but also you're going to hear me talk about some new claims, a lawsuit, if you will, that they're bringing against the PAC. So the first one's pretty self-explanatory. Declaration of the termination fee is enforceable. So they're just saying, hey, this whole thing's enforceable. Let's move on. We're done here. So that's pretty easy. The second one here, breach of contract. So they're bringing a breach of contract claim against the PAC. The PAC did not negotiate in good faith. You heard me kind of lay that out a little bit in advance of getting to this here. And the Mountain West is entitled to recover its attorney's fees. You're going to hear me talk about that several times as well. Number 3, they bring the F word, fraud, promissory fraud. The PAC knew their representation surrounding the termination fees were false. The Mountain West reasonably relied upon the PAC representations, and that reliance was a substantial factor in causing harm. So the Mountain West is saying that the PAC knew when they approved and agreed on to the scheduling agreement and what they represented as part of those negotiations and agreements, they knew what they said is not what they actually thought. Basically is what they're saying. So they're saying you basically lied, which is fraud. And, that's clearly an issue. Number 4, torturous interference. The PAC knowingly and deliberately interfered with Mountain West members. The Mountain West cites the Mountain West Handbook and the Mountain West bylaws for a conflict of interest. And I talked about some of that stuff just a little bit ago because it goes right into this claim here. But a conflict of interest and for proper resignation from the conference. These two factors are key when looking at the timing of all that occurred. And they go into a lot of detail. Again, check it out if you're interested. Here, the Mountain West appropriately cites the portion of the PAC membership terms that state that a departing member, quote, shall provide the Mountain West with written notice of its withdrawal therefrom and provide the PAC with a copy of the notice, unquote. I have been talking about this ever since I saw the term sheet. I've been asking why aren't they doing this? Why haven't they done this? I asked you this, and your answer was because they don't have to. And you're right, they didn't have to.
Right.
But then you can't take a picture, and
Yes.
you can't do all of these other things, and you can't have your cake and eat it too. You either are or you aren't.
Yep.
And they're really, in my opinion, painting themselves into a corner here, saying one thing and doing another. And quite frankly, it's almost flip-flopped when we look at the exit fee case, which I'm not going to get into now. And they're cherry-picking when they want to be and when they don't want to be members. And I think this tortious interference, to me, is a huge deal. They have multiple cases here in terms of, or they cite multiple items in terms of the conflict of interest, how it's supposed to be resigned. They talk about the PAC term sheet that they all signed that literally says the same thing. I mean, to me, this doesn't look good for those members. But again, I'm not the judge. And so the Mountain West here seeks judgment against the PAC, including compensatory damages, attorney fees, and any other relief the court deems appropriate. And then the last one here, unjust enrichment. So this claim is only if the scheduling agreement is deemed invalid. Okay, so this is kind of like a Plan B, right? Plan B type of deal. Here, the Mountain West requests restitution in the amount of all the benefits unjustly retained by the PAC and disgorgement? Disgorgement of any profits obtained as a result of the unjust enrichment. So throwing a lot of different things here. I'm not surprised to see fraud brought up. I'm really not surprised to see tortious interference brought up. And then they kind of have this, well, if everything fails, we're going to throw unjust enrichment in here as well, Steve. So what are your thoughts on these claims by the Mountain West?
Well, again, I think some of them are basically just like, you got to do this. Like,
Yeah.
Especially with all of the evidence that is out there. A lot of that is just going to depend on the mood and the feeling of the judge. We saw that in the original PAC case where he was just like, like I believe their agreement said you had to submit in writing by a certain day or whatever. And he's just like, they told the world they were leaving. That's good enough. You should have noticed. Yeah. Which another judge may have looked at that like more like just strict to the letter of the law and said they didn't do exactly what they were supposed to do. So, but that judge read it a certain way. So a lot of those things are just going to be, up to the judge. What I think the overall kind of theme is again, going back to what we talked about, the PAC is trying to make this all about antitrust, anti-competitive practices or whatever. And if they can knock the whole case out, out by that, great. But if they can't, then we're going to get down to this stuff. Who did what, when, and all of that. And so I think this is a way for the Mountain West to put more pressure back on the PAC, which that's what all these moves are.
Yeah.
Move, counter move, see who can put more pressure on the other side to get them to cave, come to a settlement or whatever. Because I cannot imagine that this is going to go to a full trial, and possibly it does, but these usually don't.
Yeah.
So again, I think the PAC's main thing is, well, this thing was never legal or enforceable from the beginning because it's anti-trade, anti-competitive, and these are the Mountain West arguments. Well, it wasn't anti-competitive, and if they get the judge to side with them, and now we got all these things we're going to come at you with. So it's like their counter for putting pressure on. In a lot of these arguments, again, it's going to come down to the judge. Look at what we saw in North Carolina versus Florida before. We had the business court in North Carolina, and that judge, it was, he's used to dealing contract law between businesses, and it was cut and dry. Every line was cut and dry. It was going to go one way or the other. Whereas in Florida State's case, in the state of Florida, they had a judge that looked at everything completely different. So I think this is the overall picture is more who can put pressure on each other, not necessarily what their claims are right now and if they're going to hold up.
And remember, I'm going to say this just to remind everybody, bring it full circle. This is a federal court in Colorado. It's Colorado because the PAC's headquarters are in California. This is a federal court in California. My apologies. And, I heard a lot of people say that could actually harm the PAC, but they had to do that to get the anti-trade piece, which is the silver bullet here. So their eggs are kind of all in one basket, but if it hits, you're as you said, and we've been saying this from the get-go, you're kind of good to go. But I think the Mountain West, they clearly put a lot on the table. I was waiting to see what would come up. A lot of what I was expecting to see. Talking about a lot of the conflict of interest stuff, the Sabo comments, the picture, all that kind of stuff. Talking about the bylaws, the handbooks. This torturous interference piece to me is huge. There's also a portion in here, and I didn't want to hog up this session. Maybe we can do another one that talks about the exact timing and how the negotiations for extending the scheduling agreement went. They have dates. They have this letter went here, this letter went there. I don't think that has really anything to do, quite frankly, with the case necessarily, but it is. They do paint the picture of how, back to that background and how we got here. They go through all of that, and I found that interesting because up until now it's been a lot of speculation. Oh, the Mountain West was asking for too much. Oh, the PAC, they never wanted to extend anyway, and it just nobody really knew. But the Mountain West adds some details into the dates and who was and how things were discussed and what the offers were. It's in here. So we'll maybe do another one. It'll be short, but I found that interesting.
It is interesting, and I'll just say establishing a timeline of what happened when, that really paints you can use that to paint a picture of what the other side was thinking. Their actions and when shows a lot about what they were thinking, what they were trying to do.
That's exactly what the Mountain West did here. So that's well put. With that, hey, we thank you guys for watching. I told you all we'd get this one out a little bit late due to me being away, but we do everything lawsuits here when it comes to conference realignment. And of course, being a Mountain West pod, we will follow this one very, very closely. So make sure you smash that like button on the way out and subscribe if you like our content. And we'll see you next time on The Big Mountain.